Please make sure your cell phones are off or silent. Court, all rise, please. Hear ye. All persons having appeals court, now sitting at Boston, within and for the Commonwealth, draw near. I say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Appeals Court. We are here today for hearing in one case. This case was originally scheduled to be heard on February 2nd and was continued due to reasons that I need not read into the record. The case number is 2022 P543, Tessa Wolfe and others versus the Boston Children's Theater and others.
Thank you. Thank you, Chief. And I do appreciate the panel accommodating me, even though we don't have to read it into the record. It was, I do still have a lingering cough, and I apologize in advance if that affects my argument. But if it pleases the court, may I begin? Thank you, Justices. For hearing me today. As you know, this is, I'm sure from a review of the papers, this is a case involving the Massachusetts Charitable Immunity Statute and its intersection, I think, with the Massachusetts Wage Act law. The Wage Act law, I think, is not as important to the analysis today. The issue that's, I think, before the court is the language of the Charitable Immunity Statute. In particular, the language that contains or sets forth an exception to the general rule that officers, directors, or trustees of non-profitable organizations shall be immune not just from damages but from suit in connection with their activities running a charitable organization. The exception at issue here from the statute says that the immunity conferred by this section shall not apply to any acts or omissions intentionally designed to cause harm or to any grossly negligent acts or omissions which result in harm to the person.
You're here on appeal from that interlocutory denial of the motion to dismiss under the doctrine of present execution because, of course, your clients, you contend, are immune from suit. But the immunity, as you just described, incorporates an exception that involves determination of questions of fact, going at least to the question of intent, right?
Exactly, Your Honor. Whether or not there was any, I think any, did the plaintiff in effect meet its burden of production at that summary judgment
It's not just production.
stage?
I mean, this is, we get to summary judgment and we have to determine that there is no genuine issue of a material fact based on the entirety of the record.
Well, exactly, Your Honor. And I would submit that the entirety of the record here shows, I think, conclusively, or at least there's no argument, there's no rational or reasonable argument to be made that these gentlemen, Mr. Badzinia and Mr. Solomon, had any other intent except to benefit Boston Children's Theater, which is the charitable organization at issue here. If you look at all of the arguments that my brother raises in his brief on behalf of the plaintiffs, they are, I guess, could be termed charitably a bit of an overreach. He makes claims that Mr. Badzinia and Mr. Solomon promised to pay Mr. Davey and Ms. Wolfe, the plaintiffs in this case, when in fact, if you look at the citations that are used to support those allegations in the brief, what those citations point to are actually words and phrases that are quite different. They all, in some, reference statements made or allegedly made by Mr. Solomon and Mr. Budzinia, even if we accept them for the purposes of this argument as true, don't give rise to the, I guess, an inference that they intended any harm.
Well, didn't their statements encourage the plaintiffs to continue to work and assure them that they would eventually get paid?
That's not what the record contains. If you look carefully at the citations to the record, what it says is that either Mr. Solomon or Mr. Budzinia at different times said that they would do everything they could, or they would work hard, or continue to work hard to try and, in effect, raise the money and make sure that that there would be sufficient funds to fund the operation of the Children's Theater. That is markedly different than what my brother has put in his brief as to what was actually said, and it is markedly different than what I think we all agree is the controlling case here, that Lynch versus Crawford case, where Mr. Crawford, the president of this Roxcomp charitable entity, assured his employees or encouraged them to keep working and assured them that they would be paid, all while he knew that it was highly unlikely that the federal grant that funded this program was unlikely to be approved for the fiscal year. I think that was the key, I think, element of the analysis in the Lynch versus Crawford case, that the person making these statements that they would all get paid knew that the source of the funding from which those payments were going to be made was highly unlikely, if not definitely, not going to be made. Here, we have something quite different. We have two gentlemen that were on this board for their fundraising acumen, and in Mr. Budzinia's case, he had a talent for building sets and things like that for the Children's Theater. Here, the Boston Children's Theater had a long history, and both Mr. Davies and Ms. Wolfe acknowledged that in their depositions and all the citations in my papers, acknowledged that they knew that it was a shoestring operation, that it all depended not upon a federal grant that they could easily determine was going to be going to be forwarded or not, or approved or not, but on the fundraising efforts of the members of its board, the parents, and classes and things like that they taught in the summertime. There was plenty of evidence that they knew that Mr. Shine, who was the executive director of the board, had for years been prioritizing payments, pushing off payments, making deals with landlords or other vendors to turn what had started as purchases for the theater into donations to the theater. There's no allegation anywhere in the papers that Ms. Davey and Ms. Wolfe didn't know that this was the case. They had experienced it for any number of times leading up to the ultimate demise of the theater in this case. And what distinguishes this case from Lynch versus Crawford even more so is that, like I said, there was a definite determination that Roxcomp couldn't meet its obligations. Here, right up until the very end, everyone reasonably believed, that everything would work out in the end. It reminds me of that movie, Romeo and Juliet in Love, when the Jeffrey Shine character says, "How's it going to work?" And he says, "We don't know, but it always works out."
I thought you were going to refer to the exotic Marigold Hotel.
that would be a good one as well. I would also refer
That was Shakespeare in Love.
Shakespeare in Love, yes. The Cane Mutiny I always use as well. I would point to Mr. Shine here, who was the executive director of the board and the person actually responsible for running the operations of the theater, as the real author of the Cane Mutiny, or in this case, the demise of.
So I mean, the distinction you're making is that when your clients assured the employees that payment was forthcoming, they actually thought it was?
First, they didn't believe. They never said that they never. If you look carefully in the record, you will never find them assuring them that they're going to get paid.
I will be working with Toby to make sure the money is there, not only for you to pay paid on time, but for you to receive the back pay that no one should have to wait for?
That he telling the executive director to do that once he raised the money, that Mr. Shine was supposed to be responsible for making sure, for prioritizing those payments and getting them paid. He never made those statements to Ms. Davy or to Mr. Davy or Ms. Wolfe. It was always, I'm going to do the best I can. Like any person, who volunteered, who donated his time, who cared about the theater, he was trying to do what he could to better the theater.
The effort to do what he can for the benefit of the theater is ancillary, however, to the question whether he took intentional acts that provided assurances that wound up harming the employees.
Well, no, they would have to be intended or designed to harm the employees. Here, the idea was to keep the theater running.
Aren't you charged with intent of consequences if you make an intentional act knowing what the consequences are likely to be?
In this case, what made the consequence inevitable that they couldn't get paid had nothing to do with the efforts, the acts that these men were making. What happened was at the very end, and this is laid out in our papers as well, is that the Boston Globe ended up publishing a newspaper piece setting out allegations of inappropriate relationships and conduct between the artistic director, Mr. Burgess, or Mr. Clark, with the students, the young students.
The children.
That was the moment when that was the Roxcomp moment when the federal grant is not going to be approved. That was when it became obviously impossible to raise any more money and continue the efforts of the theater. Mr. Solomon and Mr. Budzinia had absolutely nothing to do with it. They had no knowledge that it was coming. They had no knowledge of any of these, of the conduct of the artistic director. There's no allegation that they did or that they should have. Remember, these were volunteer people, volunteers, unpaid, that all they did was care about this theater. Mr. Budzinia, because he had children that had participated there. Mr. Solomon, because he loved supporting the mission of the theater. And he, at every turn, on every act, it was designed to help not just the theater itself, but the employees as well.
It just seems to me that a good bit of your argument, the distinction that you're seeking to draw, is between intent and malice. And I don't understand the requirement to be actual malice.
It's an oddly worded phrase, if you ask me. This, they could have said.
Well, I understand that, but we do have. We're not left just with the statutory exception. We also have its construction in Lynch.
We have what
the harsh result. I will grant you that.
What we have, and it's the analysis is so much more favorable to Mr. Budzinia and Mr. Solomon in this case than it was to the president in Lynch. I guess if this case doesn't get the immunity from suit and from damages that the Commonwealth conferred upon on volunteer, uncompensated directors of charitable immunity, of charitable institutions, is there a case out there where it's real, where it could actually be effective?
Yeah, if the person isn't the president or treasurer, and if the person doesn't encourage people to keep working when they're not getting paid.
Well, remember, he didn't remember. And I know, and my brother again overreached at this point too. I think at some point in his brief, he has Mr. Solomon referring to Mr. Wolfe and Mr. Tessa, or Mr. Davy and Ms. Wolfe as morons. If you go to the actual, excerpt from the deposition that my brother cites to, he's saying they're not. He's saying that when he talked to them, they knew the situation. Nothing was kept secret from them. They all assumed that they were going to get paid because of the efforts that these two men and others were making to raise the money.
If this were a for-profit corporation, then they would, regardless of what they were paid as directors, they would be subject to sue.
Well, that would be under the wage statute, and again,
Yes.
I think the analysis really is on the immunity statute.
I agree with you, but well, we do have Lynch to deal with, and there are rules for treasurers and presidents, and there is, I assume, D&O insurance available for people even on nonprofit boards, so, right?
Well, in this case, I don't know that it's particularly relevant to the analysis, but the D&O insurance here provided for payment of defense costs. It does not provide
Well, all right,
anything as
so,
it
but
relates
it's not, that's
to-
not relevant here. If
to
Lynch
damages.
or this case winds up meaning people ought to insure themselves if they're going to be president or treasurer, then that's what it'll mean. I mean, right, there's two sides of this coin, and I feel a bit like the SJC and Lynch chose a side.
Under a peculiar circumstance where we have someone who actually knew that there was no chance that payroll would be met. Here, every inference that should be drawn is that they had no idea that their efforts were going to be
We
unsuccessful.
talk about
They
inferences
had
on the
always
summary
been.
judgment standard. We have to draw the factual inferences in the light most favorable to the non-moving party.
Exactly, but you still need to have an inference. If you're going to have fact A, if you can establish fact A, and even if we give that fact A as being most favorable to the plaintiffs, you still need fact B to flow logically and rationally from fact A. Here, my brother is trying to say fact A is, look, they promised them to be paid, like Justice Rubin, like you were saying, they promised them to be paid, or Justice Massing, that they assured them that they would be paid. That's not true. Fact A does not equal that he assured them to be paid. Fact A was they would do the best they could to make sure that there was money to pay.
The affidavits in the record at 298 to 300 characterize the statements in a little bit more emphatic and unequivocal terms.
The brief, I think, characterized those
Oh, I'm
statements.
talking about the affidavits, the factual
think
record.
If you read the affidavits closely, they all, I would say, at Mr. Davey, at paragraph 8, in the second volume, page 298, is, let's see if we can get you paid. Davey testified.
I continued working for BCT because I expected to get paid in full, in part because Mr. Solomon indicated that he would work to get me paid.
Exactly, he would work to get him paid.
Then go to
and he
page
did.
300.
But those are jury questions anyway.
Well, again, the question is did he not work? I guess if he had lied to them and he knew that he wasn't going to work, then there would be an argument that he had some design or some intent to harm these people. But it was actually true. He said he was going to work. He continued to work. He did everything he could until the demise of the theater was caused by the allegations against the artistic director that were published.
I think we have your argument, and we're over time, but thank you. We will review the record carefully.
Thank you.
Thank you.
Thank you, Your Honors, and thank you for indulging my request for a continuance and for letting me be over time.
Of course.
Thank you.
All right, for the plaintiffs?
Good morning, Your Honors, and may it please the Court, Raven Moslinger for the appellees. I first want to note that the Wage Act here is actually important. The Wage Act requires a timely payment of all wages, weekly or biweekly, within 6 or 7 days of the pay period in which the wages were earned. So the plaintiffs here were former employees of Boston Children's Theater. They consistently worked without pay and are still owed thousands of dollars as of today. So in fact, they were subjected
But
to...
the narrow question in this appeal is the applicability of the charitable immunity to the defendants.
Absolutely, Your Honor, and I think the narrow question is whether...
Individual defendants.
I think the narrow question here is whether a jury could possibly conclude that the defendants acted with intentional design to harm the plaintiffs on these facts, and as the trial court found, I think the answer is of course. Now, at the outset, and I think the justices have touched on this, we're dealing with a question of intent, and this court has routinely said that that's ill-suited for deciding on summary judgment. It's better left for a jury question. But
Well, does that mean then that the claims of immunity in these cases are categorically unsuited for present execution?
No, Your Honor, I don't believe so. I think in circumstances where there's a complete absence of facts demonstrating that, there was any actions. For example, if these individuals had just been normal board members who weren't getting involved in the nitty-gritty of deciding who gets paid and who doesn't get paid on a day-to-day basis, then this case might turn out differently, but the facts are markedly different. Sort of honing in on the guidance that the SJC provided us in Lynch versus Crawford, there's three sort of hallmarks or examples of activities that can get you to a jury with respect to the question of intent. And that's one, whether or not the individuals are prioritizing payments to vendors over employees, whether there's encouragement to work even when it's unlikely or known that folks are not going to get paid on time or in full. Well, I guess those are the two sort of main hallmarks. And now the SJC didn't say that all those were necessary in every case in order to get to a jury on the question. But here, as to both defendants, there's evidence in the record supporting each of those sort of indicia of intent to harm. Now, Mr. Benzina was the treasurer of the company. He managed the finances, he approved payroll, and he had complete knowledge about the continuous failure of the company to make payroll, including as to the named plaintiffs. During a meeting and during conversations with Mr. Davey and Mr. Shine, he did encourage them to continue to work, said he would work to ensure that they got paid. And yet, even though he made those assurances, on a monthly basis, Mr. Benzina was approving expenditures to vendors, which he admitted that money could have gone to pay employees rather than vendors, but continue to make those payments regardless. So unlike in Crawford, the SJC pointed at prioritizing two vendors and said that the president's prioritization of two vendors was problematic. Here you had Mr. Benzina in every single month approving expenditures going to vendors instead of employees when he knew that they were owed back wages. And Justice Green, I believe you touched on this, it doesn't really matter what they said, it matters what they did. When you're weighing intent, sort of black letter law is people intend the natural and probable consequences of their actions. Here, if you were approving and paying vendors when you know employees are not being paid, the consequence of your action is that you're harming those employees, and therefore that's your intent. And so turning to Mr. Solomon, he was the president and treasurer of the company at various times. He also had knowledge of the consistent failure to timely and completely pay the plaintiffs and other employees. He encouraged Mr. Davey to work, Mr. Shine to work. You quoted from an affidavit from Jay Pension, another employee of the company who he encouraged to work, and that was not something that was said to the board, that was something said directly to the employee. And he assured them that he would continue to work to ensure that they would be paid in full with respect to their wages. Now, of course, a couple issues, even though he made those representations that he would do everything he could to ensure that they would get paid, he also prioritized payments to vendors over employees when people were paid or were owed back wages. And I think the more egregious of things that happened was on November 9th, he asked Mr. Shine, how much are the named plaintiffs owed? How much is Ms. Wolfe owed? How much is Mr. Davey owed? And he found out exactly how much they were owed. Days later, he directed some of Boston Children's Theater's limited resources to repay a private donor rather than my clients. So, those are actions that the natural consequences of those actions are to harm the named plaintiffs, to harm other employees. The statute also addresses omissions that are intentionally designed to harm. The record reflects that Mr. Solomon at all times had the ability to file an insurance claim with respect to people's back wages, and he failed to do that until October or November of 2019 when it was too late. That is an omission that is directly designed, that directly harmed the named plaintiffs. And you can read the quote for yourself with respect to where Mr. Solomon, he said, and I'm paraphrasing, that folks who continue to come to work without getting paid must be morons.
How much money was owed in wages when the money was paid for rent instead?
At the time, Mr. Davey was owed approximately $20,000, a little shy of $20,000, and Ms. Wolfe was owed $9,250. The email that Mr. Solomon received is Record Appendix, Volume 2, number 264.
And how much was the payment in rent?
I I don't have that figure. I think it was I don't want to misstate it. I think it was under $10,000, something
Okay.
along those lines.
Let's say he had instead directed the payment to maybe I know your answer to this, but let's say he had directed the payment to the people who were owed wages under the Wage Act. $9,200. So now they've got, I don't remember what you said, $49,000 or something of damages, and they've gotten about 20 cents on the dollar, $9,200. And in the end, I gather they got nothing, but okay, let's say that's what happened that day. And the next day, the theater company closes, because if you don't pay rent on the place where you do the theatering, you can't have a theater company. There's no way to make any revenue. You just shut. So they do. And let's say at trial, and of course there are inferences here, so this may not matter, and maybe that's your answer, but at trial they say to this gentleman, weren't you trying to avoid paying the people? Not just trying, didn't you avoid paying them? You knew they were due money. That's what has priority. It's the Wage Act. There's no Rent Act. There's a Wage Act. And so you had to pay that first. And he says, we owed them $50,000. I knew the only way we'd be able to pay them was if we remained a going concern, earning revenue to pay them in full. And I knew that if I gave the money to them that day, they'd get 20 cents on the dollar, and that would be the end of it. Could the jury find that they acted with intent to harm? Am I reading it too broadly? Does Lynch say, yeah, that's still intent to harm, even though, in fact, what you're, right, there's purpose and there's purpose, right, and there's intent and there's intent. Even though in your heart your idea was, if that's where ideas are sometimes, was to help these people by keeping the theater alive so that money could come in and they could get their pay. But your intent was also, quite clearly, not to pay the wages due, but to pay something else instead. Intent to harm, no intent to harm.
Intent to harm. And the reason for that, and I think you can get this from Lynch, is that wages are sacrosanct. And there is a Wage Act, and the Wage Act says shall compensate, shall pay employees. And when in Lynch, when the SJC said that the president of the company was prioritizing vendors, it didn't say, well, but it was a good idea. It said he was prioritizing vendors. And that's the SJC's construction, is that if you do prioritize vendors, then that is, you're acting with potential intent.
And in the event of a violation,
Pardon?
in the event of a violation of the Wage Act, like pre-existed here when these payments were made, is there any mechanism a business can use, any agency with whom it can negotiate to say, look, yeah, we want to pay these wages. Here's our bank statement. You'll note that it says zero. So we don't have that money. Now, I'm about to get a donation for $9,000. Someone is willing to donate it or whatever, or I have it. I can pay the rent. We can stay in business and try to pay these people, or I can just give it to them and they're done. Is there some place in our government where someone can say, or the legislature decided this in the act, where someone can say, all right, we're going to let you try to keep the business a going concern. We understand that you're in violation of the Wage Act and you're not paying them, but we also understand that you're legitimately trying to get more revenue so that you can pay them, among other things.
There isn't presently an avenue for that. It's a strict liability statute and the failure to pay wages.
Well, I just think about the IRS, right? The IRS has agents. They come places. Maybe sometimes they're just law enforcement types, and they're like, you didn't pay your taxes, we're sending you to jail. But if the person has a good lawyer or accountant, the lawyer or accountant will say, like, look, does that do the U.S. Treasury any good to put this guy in jail? He runs a printing business.
Sure.
Let him stay open. And
Sure.
here, let's come up with a payment plan and see if maybe this can be resolved so that you get the revenue, your revenue agents.
And I can only speak to what I know with respect to the Attorney General's authority, but the AG's office does have parallel authority to enforce the Wage Act, and I do know that they do engage in these sorts of
But the difference here is that the individual employees who are entitled to receive the wages are empowered by the Act, in effect as private attorneys general, and there is no cognate opportunity for waiver, and maybe that is an anomaly in terms of what would be best public policy.
Correct. I think it's really a sort of a public policy issue. Employees have a right to be paid their wages in full and on time. The difference between getting paid and not getting paid is sometimes people.
Well, I guess one of the challenges of this case and in Lynch is that in a charitable organization where there is a legislative intent, objective, to provide immunity in light of the nature, it may not achieve that intended effect.
That's fair, and I think.
If your argument is
Yes.
sustained.
Well, I think that's fair, and we're left with the statute as it's presently drafted and constructed by the SJC. And the denial of summary judgment does not mean we win at trial. It merely means that there's enough evidence in the record.
Well, but the immunity is not immunity from liability, it's immunity from suit.
Correct. Well, that is correct.
Well, both, right? Presumably, you could get a judgment, a defendant could get a judgment in their favor if they persuade the jury that they didn't act with whatever the bad intent is that's required.
Right. What the trial
I mean, I don't know what
court-
the instruction looks like exactly.
What the trial court held was essentially that there were disputes of fact with respect to the defendant's intent. And so,
I'm sorry, Rubin. Is there a difference between, you intend the natural consequences of your act. Is there a difference between intent and what the statute uses the word intentionally designed?
I don't think so. I think it's sort of an oddly drafted statute, but I don't think that there's.
That word's got to mean something, right?
Sure. Well, I guess if you sort of peel back the onion of Lynch, perhaps there's sort of this element of design in the sense of I'm going to sort of encourage people to work. I don't know if we're going to be able to make payroll. I'm going to tell them we're going to try our best. And you're sort of bringing those things together to sort of establish a design. The SJC didn't say much with respect to that, but just said, hey, look, there's these three factors that we've identified here. This would be enough to get to a jury on the question of intent and design. So, Your Honor, I think this back and forth demonstrates precisely why questions of intent are usually best for a jury to decide in a jury room as opposed to in this sort of courtroom. And unless there are any other questions, I'll otherwise rest on our brief.
Thank you. I see that your time has expired. That brings us to a conclusion of this argument, and with it, the conclusion of this rather brief session this morning. Thank you both for your arguments.
Thank you, Your Honors.